Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, OraSure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics. Hello, and thank you so much for joining us for our first session of the 2023 Day with DISA Educational Conference. This session will be specifically on cannabis and cover new state laws and testing considerations. Today, we're joined by Faye Caldwell, legal advisor and litigator at Caldwell Everson. Faye, how are you doing?
I'm doing great, Thomas. Thank you so much for having me.
Well, before we jump into that presentation, I want to remind everyone that if you have any questions, use the Q&A button at the bottom right of the player, and any questions we're unable to answer today, we'll work with Faye to get an answer and get that back out to you a couple days after Day with DISA. Additionally, we'll make a copy of the presentation available for download in the Materials tab after the session. With that being said, Faye, the floor is yours.
Thank you so much. As we really offer a look back at 2022, we're going to get whatever we can for what we think the preview of 2023 is going to be like, but really here to give you some massive changes, some innovative information as we watch the states look at cannabis laws, and really give an overview of some societal information that may make a difference just so we understand where we've come from and where we're going. So first, you know that I'm an attorney. I do practice in this area, and I'm delighted to be able to provide you the legal perspective of what's going to be happening now. As always, this is not legal advice. We don't have an attorney-client relationship, although with many of you I may, but not today. Today we're talking about information. So first off, I think, and I'm increasingly seeing the need to look at where we've come from, because I think that helps explain where we're going and what the changes are. You know, no crystal balls, but I think sort of putting everything in context helps us know and make sense of as changes go on. So really, I'm going to go back to the beginning of the federal drug testing program, where really the overriding principle for cannabis, but all drugs, was that the presence of illegal drugs in urine, that's what we've always had, was sufficient to remove people from safety-sensitive position, even if the use was historical and didn't reflect sort of what was happening in the employee's body at the moment. So that is still the rule under the federal program. But we're seeing a lot of change in this, and cannabis is really the forerunner, and I believe tells us sort of where things are going. And as we look at state laws, it increasingly reflects an opinion that illegality in a historical context was over-inclusive. And it is not really targeted to see if there's a safety risk in the workplace. Again, we don't have to agree with that or not agree with that, but that is, in fact, as we look at the trends in cannabis law, the reality of where legislators and voters are going. So we have a new focus on impairment from cannabis, and we're going to do the states sort of focusing on New York and New Jersey, which really talk about impairment on the job. Difficult. But that's where we start from, and that's where we go. And this is our new sort of what I'm going to call our reality, that we're really focusing on, and historical illegality of cannabis use may not be good for employment making decisions. Now, of course, that begs the question, what is impairment? I really, really wish every time I come here every year that I could give you a definition that is all inclusive and we could take to the bank. I still don't have that. As we know, there is currently no standard drug test that provides reliable information on what constitutes impairment in the workforce. We have standard urine, oral fluid, hair, all of which look to varying degrees historical usage. Even blood, which is not a standard drug test used in employment settings, isn't have any agreement of what impairment would be. When is somebody unfit to work? How long does it take after usage? These are all questions which we're grappling with, and I'll do my best to provide insights, but there is no current national agreement on that. And of course, under the federal program, it's not an issue. That is not a topic that comes up under current federal drug testing scenarios. So we're going to talk about cannabis, and we're going to talk about the laws as they exist today. As always, I don't promise for next month. There's a ton of states that are looking at cannabis legalization as the new legislative sessions are starting. So this is where we're at today. First, saying it out loud, you've already gotten a hip. Marijuana is still illegal under the federal law. Please note I use cannabis and marijuana interchangeably. There's a change generally to cannabis, but the federal statutes talk about marijuana. Recreational marijuana use off duty, medical marijuana use off duty, hemp products are not legitimate medical explanations under the US DOT drug testing, or for that matter, under HHS drug testing. It simply isn't a conversation that has. That is because federal laws preempt state law, and regardless of whether in your state medical or recreational cannabis is legal, it doesn't change the federal program. It is still a Schedule I drug. And I can tell you the federal agencies are holding steadfast on this. It's simply not a conversation that has any relevance to federally regulated drug testing. Now, the question always comes up, well, since it's federally illegal, why do I have to even pay attention to this? That is because what has happened is a budgetary issue. The Department of Justice is not enforcing federal marijuana laws in states with medical marijuana, nor as best we can tell in states with recreational marijuana. So they aren't swooping in states where it's legal and arresting people under federal laws. And what has happened under state laws is the state criminal penalties and the state enforcement has gone away. That's what the state laws did. It decriminalized cannabis usage to whatever measure the individual state has deemed it. So with that, and this is not a change, this has been enforced for about 10 years now where there's been not federal enforcement. So what has that done in the environment? Well, it's really pretty easy. Positivity goes up. And now I'm talking about in the workforce, general workforce testing. I'm not talking about the driving public or people. My statistics come from Quest Diagnostics Drug Testing Index. That is general workforce urine only. And the other thing with this is the percentage of drug test panels that include cannabis is decreasing. And again, we'll be looking to Quest Diagnostics Drug Testing Index for this. This is a trend that we're going to look at, and I'm going to give, I don't have 2022 data yet, but we're going to talk about what we think is going to happen. So look at this. This is just overall. This is states where cannabis is legal under some circumstances, cannabis medically is legal, or there is nothing. But in all of them, the positivity rate is increasing. In 2012, so 10 years before the 2022 review, the positivity rate, 2%. It is now 3.9%. I don't like to look at my crystal ball too much, but I predict it's going to go up as we have still more states coming online in 2022. Additionally, look at the percentage of tests in the workforce that include cannabis. Massively decreasing. 2015, which I know to me seems like just like yesterday, 99.6% of all general workforce tests in urine included cannabis. In 2021, we're down over 10 percentage points. What do I think the trend this is? That percentage will massively decline. Why? First off, in 2021, and you're going to hear New York mandated for non-federally regulated that generally testing for cannabis was not allowed. So we would predict, as one of the largest states in population, that New York in and of itself will drive the percentage down, even as a choice that is not made necessarily by employers, but mandated by the State Department of Labor. Additionally, when we get to 2024, California is what we're going to talk about. California will not allow testing for metabolites. So what does that look like? It means if it goes into effect as is currently promulgated, we could always have change in 2023, you're going to see California come off for everything but right now oral fluids. So that means hair and urine testing in one of the two most populous states evaporate because it's not going to be allowed. Or I shouldn't say that. It can be tested. You just know employers can't use it. So I think that, you know, the utility in a state like California is going to go massively down. So with California, New York really coming off the grid, you're going to see that number go on. What it will be like, I don't know, but I think that's a trend that's going to continue. We'll see what happened in 2022 once those numbers are available. But this is going overarching, and we do know from all the states, and we're not going to get into sort of individual states, that when cannabis is legalized recreationally, not so much medically, but recreationally, positivity in the general workforce goes up, and often quite dramatically. That has been the trend since 2012. I don't have any data to suggest that will change. So let's look at the numbers. As of January 10th, 38 states, yes, I have an asterisk there, plus DC, plus 4 US territories have passed what I call medical marijuana laws. We'll talk about those. The asterisk is Kentucky, and we'll talk a little bit, being very, very imaginative. They've limited the penalties for cannabis usage by executive order. We'll talk about that and see what happens. Additionally, 21 states, not quite half, DC plus 3 US territories have passed recreational cannabis laws. To give that as a trend, 13 of these are since 2018, in the last 5 years. I can tell you that we don't know where the legislative session is going to go in 2023. As I gather the data, many, many states are busy proposing cannabis changes in their states. How many of those will end up at the end of the legislative session on board? I don't know. A lot of them will not, but there is some that at least the pundits, for what it's worth, are predicting that will pass. They will all be different. Remember, this is not generic. We have one overarching federal law that goes everywhere. Everything else is individualized. Guam is different than what Kentucky did. And to talk about them in general just really isn't very useful when it comes to employment. So let's look at this by the state. This is just sort of this is a by year. If you're interested in, this is more historical for where we're going. It'll tell you the year, and we've highlighted those that went through 2022 of seeing changes in medical. This is only medical now. 38 states, Washington, D.C., moving on, we'll see what happens. So state recreational laws, you're going to see again, there were 3 that passed legislation for the first time for recreational cannabis, and we're at 21 states. And you can see again, the trends are moving towards this. Here's our map. You're going to see there are large blocks, and there are still quite a number. And this is the light green, the very light green, that have high THC, low THC, high CBD laws. And those are ones that we're not going to really talk about, where they have some allowance in varying degrees of using high CBD for medical conditions. These are still on the books. I have to tell you, with the passage of the Farm Bill, they've become a bit less important because CBD is in fact legal now. So, but they're on the books. There is only 2 states that have nothing, and that's Idaho and Nebraska. And At least I've looked, at least they're looking at both of those. Again, whether they pass or not is simply another one. So that's the big overview. Let's get to sort of the updates and sort of see the changes in 2022. We're going to be covering everything, but we're certainly going to highlight the changes that we've watched throughout the year. So really what we have, Kentucky, limited, Mississippi, Maryland, Missouri, and Rhode Island that all went for some sort of it. And we're going to talk about what each of those mean in overview. You're going to have the slides. Thomas has promised to make them available so you can take this as reference material when you go on and go further. So for our group, what we're really interested in is beyond the fact that there's legality is how does that impact the workforce? So we're going to focus on the idea of employment protections, where it's at, where it's not, and kind of where we don't know, to give some people to look at. So if you have employees in these states, you're going to want to look at these because these are changes. So we're seeing a trend towards states that already have cannabis pass additional laws to give employment protections, both recreational and medical. So first off, and we're going to talk about this one later, cannabis, the California, which was, of course, one of our first states for medical and one of our early adopters for recreational, in 2024 has now added protections for medical and recreational off-duty use. As an aside, is it still true that being impaired on the job or during working hours is not protected? 100%. You do not have to generally tolerate usage nor impairment in working hours. Now, there is some states that have taken care of our remote workforce, but the answer is during working hours. It is no longer just workplace because a workplace isn't just any more brick and mortars. But effective January 1st, 2024, California added protections. And so we're going to grapple with that for both medical and recreational. So even if they test positive for legal off-duty use, there's going to be restrictions on employers of what policies can contain and also what actions can be taken. Missouri has added protections for medical usage. Missouri is a medical use only state. New Jersey, which has have finally provided some guidance. All of us were sort of waiting for the guidance material with their passing of their cannabis laws. And Washington, D.C., a small place, but we're going to look at Washington, D.C. closely because this gives us an idea of where innovation is going to protect employees and see some ways to do it. But that is in place. So we also are seeing a trend in the public sector, okay? So the idea of public employees, state employees, do they have protection? Which traditionally, that was not so much thought about in the years past. But Louisiana and Utah both have passed it, and they have very unique ways of what matters. And then we're also seeing at the city level. I will tell you that oftentimes grassroots cannabis starts literally in municipalities and then moves on to states. So when it comes to trends, we like to keep an eye on them, not because we think all of you are concerned about your St. Louis or Kansas City employees, but the idea of looking and being aware of them because it provides a little bit of insight of where things are going. And so you're going to see both of those have added pre-employment testing for cannabis for most prospective government employees. This adds private sector limitations on pre-employment, for example, in Washington, D.C. And Philadelphia. So again, a municipality are actively engaged in where this is going. So here's some of the fun stuff, or not so fun, depending on your perspective, but you really need to know. We've traditionally been involved in either voters or legislators changing cannabis law. And we kind of knew that it was coming, and we knew that it would either come by voter initiative or the legislature and working through committees. We're really seeing some differences. And I want to really highlight these for you because as the cannabis industry, and I'm going to call them sympathetic government officials, see roadblocks. Something's not going to get through the legislature for whatever reason. We're seeing some innovative issues, and for a variety of reasons. So let's first look at one that's, I'll be fair with me, kind of surprised me, and it's Kentucky. Kentucky does not, prior to 2022, did not have anything. You understand, they didn't have medical, they didn't have recreational. My best memory is they did have a little high CBD law. But look what they did in mid-November. Executive order. Now, we've all heard of executive orders working in the federal government and doing things that didn't get through the legislature. My memory is I don't have anything for this in the cannabis space. So this is, regardless of how important it is, it's more important for the initiative and the ideas people look at it and how we're going to do it. So let's provide this. And this is all the governor. Okay. This is medical only, not recreational. And it's in effect now. It provides pardon automatically in most cases for anyone charged with criminal possession of marijuana under Kentucky state law. So it's like, I don't want to call it a get out of jail free card, but it's kind of that. That if a Kentucky resident or a person in Kentucky, let me make it clear, is in Kentucky and gets charged with cannabis that they purchased lawfully in another state, they went across state lines and got it, they get it as long as there's certain qualifying condition. Because remember, it's medical, there's limits on amount, etc. So it's like I don't know how this is going to work. Again, we've been, just a few days into the year of what this is going to look like, but it's an executive pardon. Now, part of me says that there's going to be a decline in the number of arrests for people who take out their medical marijuana card from Colorado, let's use it, and say, I have a medical marijuana card and I fit Kentucky. But I don't know that for sure. The data is going to have to be gathered and looked at arrests and things like that and see how this goes. But it is something that we have not seen before. This does not reference or address employment. We do not know what this means at all for sort of the workforce and what employers can do. But it just was signed in November. We don't have any real guidance around it. For me, I'm watching this space because it is really something novel is the best word I can use. Not passing judgment whether it's good or bad, it's just novel. And I think as we work in this space, that's kind of where we have to stay, because we have to deal with the reality under our drug testing programs and be aware it's out there. So that's Kentucky. I don't have a lot to say because we don't know much, but let's go to Washington, D.C. And we're going to talk quite a bit. Again, Washington, D.C. is not a big marijuana market in terms of states. But again, if you were going to give gold stars for innovation, the mayor of D.C. might get one. So historically, let's sort of talk. In the city of Washington, D.C., they have passed both medical many years ago, as well as recreational. But for those of you not attuned to the federal budgetary issues in Washington, D.C., Congress has to allow budget to allow something to go into effect. And what has happened with their recreational program in Washington, D.C. is Congress has never done that. So they don't have any money to set up a program, to set up dispensaries, to issue taxes. So it's sort of been at a dead standstill for a number of years. So what did the governor do? Apparently felt that this was important. In July of this year, he signed emergency self-certification. So if a resident of Washington, D.C. says, I think I need cannabis medically, that's good enough. You don't have to get any doctor. You don't have to get anything. It's that they are enough to self-certify. No physician's recommendation, no pre-existing conditions of, as someone phrased it to me, I think it'd be good for what ails me. And that has passed and it's now in effect. What this done effectively, of course, is create a recreational marijuana market without having to go through Congress. See, because in 2015, as I said, it was prohibited to tax or regulate recreational marijuana. So now they're now doing it through a medical. We'll see how this plays out, okay? But hadn't heard of this one either, but it is innovative. But let's look at their amendments. And again, this is really due to the fact that Washington, D.C., it'll be interesting to watch whether a roadmap is created for other places in the country. So this is the Cannabis Employment Protection Act of 2022. It was effective in October, mid-October. There does now have explicit employment protections for both medical and recreational cannabis, okay? Now, this is, even though they can't tax it recreationally, the point is for employers, add this to the list. Now, here is something that, as a student of drug testing service agent, interests me. They have the provision that medical cannabis must be treated the same as other prescription medications. I want you all to think about MRO issues all of a sudden, because traditionally, cannabis is reported by the lab as positive, regardless whether there's a recreational, medical, or whatever that's left up. I think, from my knowledge of the industry, most MROs, in my knowledge, in fact, I don't know anyone who doesn't report it as positive. And the vast, vast majority would put a comment of some sort saying, claims marijuana cardholder status, claims medical marijuana, said something to give an employer information that this person is claiming medical cannabis usage. But it is reported as a positive. Now, what's interesting, and there's a couple places in the country that are sort of looking at this, is that's not what we do with prescription medication. What we do with prescription medication, and this is mentioned several times in the DC Amendment Act, is the idea that it is that those, if you have a controlled substance, hydrocodone, you report it as a negative if there's a valid prescription. What we don't know is, will the industry change in Washington, D.C.? And what that would mean, frankly, for the industry, for the employer. This is a big question mark to me, and it will be interesting to see it, because we currently do not treat medical cannabis for reporting purposes, same as we do prescription medications. The Act does contain safety-sensitive carve-outs. There is mandatory notice provisions. Anyone who has employees in DC, there is mandatory notice provisions. And there are penalties and enforcement. It's treated as a disability, which is not unusual. I can tell you there are certain states that treat it as a disability. But again, it has this language. It would have to treat the legal use of it as any other prescription medication. And here are some of the exemptions. Obviously, you don't have to violate federal law. You don't have to have employees use on the job or be in a safety sensitive position. And you don't have to allow use controlled by the employer. Now, how come it's phrased that way? We're starting to see that. It's because of their remote workforce. So these laws, and I will sort of say this generically, but this is a good example. With remote workers, that's why we're talking about workforce or working hours. Typically, these laws allow an employee, if it's legal now, to smoke in their home in off-duty hours as long as they're not impaired. But if they're on a job site, they don't have to allow use at all. And this is sort of, as we move, post-pandemic, this is just an interesting nuance that it is generally workplaces, you don't have to have use. But if you're remote working, i.e. at home, its working hours. So be aware of that nuance when you look at your policies. If you have a large scale remote workforce, it changes things. Interestingly, it expands the definitions. Unpaid interns are covered under DC. Now, I think this is mostly DC because of all the unpaid interns that work in the DC area. But medical cannabis patient covers not only people that are DC residents, but people who are medical cannabis programs in wherever they reside. Most people don't reside in DC, but this, for example, as far as DC employers, would cover someone who would have a medical marijuana card in Maryland, for example, but was tested in DC. So just so you know, it's different. It's a little more expansive, I think, to cover. My best guess, I don't know this from data, is the idea is because there are so many people that travel into DC to work that don't reside in the district. These are all the exceptions. Now, this does give a definition of impairment. We're going to talk about this, but impairment is, we'd like to have impairment is impairment is impairment, and it apply all over the country. It does not. Most states don't define it, but those that do can do it in a very, very additional way. And we now know in DC, the fact that a drug test is positive is no evidence of impairment. That should not be a surprise to anyone. But this is definitive articulable system. The standard for impairment, in my opinion, with some of these states is getting more onerous on the employer. So you need to know what the standard is, draft your policies to really look at this and go forward. Okay, so when can you not have to pay attention to this? Safety sensitive, federal law, basically on the work site or work hours. Okay, this is fairly standard and it doesn't provide. So most of our standard drug testing, how do you figure out when they use, unless you catch them at them, it's hard. So this is some of the safety sensitive. I've good for completion. This is not inclusive, but I do, as with all safety sensitive, it's up to the employer beyond the list of qualifications. It's up to the employer to make sure that they're the ones who have to justify it being safety sensitive. I remember in the early days of this conversation, someone told me, well, they drive to work, so they're safety sensitive. I had to politely suggest that perhaps that was a bit over-inclusive under what the legislatures thought they meant. The burden is on employers to identify safety sensitive. Now, you're going to talk about notice provisions here, and this will be important, but we're going to make it broader. Again, Washington, D.C. may be the current recipe for the future. So compare your policy to some of these things and see how you'd fare if it came out to be in the state where you have employees. Here's the notice requirement. And by the way, this is in effect today. You have to give the notice to them. Now, I will tell you, you see this lovely thing where OHR shall publish a template of notice in 45 days. That would have been at the end of November. I checked this morning and no template. We'll keep looking for it, but as of right now, we don't have one. And it tells when you have to give it. You have to give it within 60 days after the date of this subsection. That's now, folks. We're already past 60 days. And new employees upon hire. So this is what you have to do, and you have to make that part of your drug testing policies if you have employees living or working in DC. They don't have to be residents. This is quite clear under this one. But always look for the notice provisions and build that not only into your policy, but also into your process to make sure that goes out first off to everyone who's working now, but also to new hires. This should become part of the employee packet, as I'd like to call it. Okay, and just because it's not onerous enough, if you don't do it right, you can have penalties. You get to double it if you violate it more than once. Lost wages, training, and my personal favorite, attorney's fees. This is a pretty big stick to making sure You can play. They can sue you and again get attorney's fees. I don't care how much they earn. I can tell you as a lawyer, though, the clock ticks up pretty high when it comes to attorney's fees. And also they can get the AG involved if they want to. But it's just, they're serious. And again, see what happens in DC, but this could, you know, I haven't seen it become a template because it's so brand new, but we need to keep an eye on this because it increasingly is, these, like it or not, these are to benefit employees from any penalty from off-duty legal use of cannabis. And they made a pretty strong stick out of this. So with that, deep breath. Thank goodness there's not all that many employees in Washington, D.C. But let's look at some of what the protections are that exist today. And this is changing, as we've already looked at. First off, 20 states plus D.C. provide language and a degree of protection. They do it in a myriad of different ways. But I've listed the states, and you'll have this as a reference, that these are the states that have explicit employment protection. What does that mean? That means either the highest court in the state or by legislature, they've given it. Sometimes it's a disability. Sometimes it's the fact they have a positive drug test. But look at these states if you have workers there and make sure you understand what your obligations are and frankly, what your rights are, because it goes both ways. So we're going to look at Missouri just as an example. This is a 2022 amendment, and this is explicit, and this is a change. They actually added it on to the medical cannabis. And again, this is and basically for all the words, it's, they don't have to, you're not, if you have to test and have to take action, i.e. federal testing, you're okay. You don't have to let them use on the job, and you don't have to let them be impaired. That's how it works. Other than that, it's an individual thing, but this is actually fairly typical. If they have a card, you really need to look and see how it is. If an MRO tells you they claim medical marijuana cardholder status, as an employer, you need to find out, A, is it true? That could be the fact that it could be expired, for example. But if it does, look at your state obligations, because it is likely to impact you. New Hampshire medical, I can tell you, someone decided to take it to court and it was left over, but the state Supreme Court said the law cannot, as a matter of law, therapeutic cannabis, you have to look at reasonable accommodation. It does state a potential claim. They didn't find it in this case because the weird postural procedure of the idea that you may have to reasonably accommodate somebody who has a medical marijuana card. Watch this space. Not everything comes in the form of statutes or guidance. It also comes in terms of state law and Supreme Court cases. So now we have the states that are easier. There are states that have said, nope, nothing to do with it. You can do what you want. And we've listed these. And this again comes from Supreme Court decision, statutes, legislation. And here are the 8 states that have found this. However, remember, they're changing. Washington has instituted or proposed legislation to change this. So as of right now, these are the 8, but watch this space. And it comes about through all of them, but you don't have to accommodate. This is again medical. This is the Mississippi medical. I don't think it could be much clearer. The Mississippi legislator wanted to kind of put neon stars around the idea that this does not impact an employment drug testing policy. But here it is for all of you. And the point is that employees just can't bring lawsuits against claims of this. We'll see it. This is relatively new, but it seems pretty stout to me, but you know, we'll have lawsuits down the road, I'm sure, to challenge it. But this is all of it, but nothing can be construed to create a private cause of action by an employee against an employer. Those are sort of things that employers like to kind of hear. It's music to their ears. Okay, Now we get to the 9 states where I may have indicia, but I can't be sure. And this is because either they don't say yes to employment protections, they don't say no to employment protections, or we don't have a Supreme Court case on it. And these are the laws. And one of them you'll see, the only one new is Kentucky, and that's our executive order by the governor that just simply doesn't talk about it all. And remember, that's kind of a weird one where it's expungement. There are some guidance, but there's no get out of jail free card on these for an employer. You have to look at it, do your risks, and see what might be. There is a trend towards recognizing employee rights. I will tell you that, but I can't talk about any of these and give you a definitive idea of where it's going to go because it's just not there yet. They all have their individual circumstance of the language and what that means. And until a court looks at it or a guidance comes out, we're left with unsure. But even places where you can't take employment action, you have state disability laws. So the idea of Wisconsin, now have it in 2019 where you have to see if you can accommodate. This is a dialogue under similar to the idea of state disability laws of could a reasonable accommodation be made? They don't give much help for that. I don't know, maybe it's how many hours before they come on the job. I'm not here to offer what that looks like, but you have to, it has to engage in the process and seeing if they can make a reasonable accommodation that would satisfy the employer and the employee's medical needs. Because again, remember, these are medical. There is something underlying it. Okay, now we're into recreational. And this is where really we're seeing a lot of movement. Employment protections. Starting in a year from now, it's California. Nevada, pre-employment only, we've been there. New Jersey, New York, and which says don't test at all unless we have some reason. Rhode Island, Washington, D.C., and Philadelphia for pre-employment. It is not, please understand that most states still have no employment protection for recreational cannabis. But we're starting to see a trend, and we'll have to see the interplay of a lot of things to see whether this trend continues. So all we can do is watch it, but there has been movement in the last 3 to 5 years. These generally are all within the last 5 years. Okay, so that tells you, before that, we just sort of said recreational, you do it at your own risk, but that's not true anymore. And it's a mixed bag. So this is California, explicit, again, work hours on the job, impaired on the job, barring that, can't really take action. The idea of a screening test, standard workplace drug test providing reason is explicitly not. So be careful about this. This is seen, comes into effect next year, but it's likely going to be pretty stout. And we're going to combine that with the testing mechanisms, and we're going to see California to become a huge cannabis question mark. So this is the complete language so that you can have it for your reference. As we talked about anymore, you can't take actions when it's metabolites. So the utility at all of a oral fluid, urine or hair, because those both tests generally in today's world for metabolites may not be of any benefit to you and probably won't be tested much. You can only take action if it's active drug, which is oral fluid in our world today, standard drug tests. So we're going to briefly go through New Jersey. So the idea, we've been on the books for a bit since the 2020 election, if I recall properly, but now we have workplace impairment. It's now a reasonable suspicion observation report. New Jersey's been talked about a lot, and this is what's affectionately called the WIRE, i.e. workplace impairment recognition expert, and what that means. This is a reasonable suspicion on steroid standards. And you need to, if you have employees in New Jersey and you want to continue to take action for cannabis positives, read closely, talk to your legal advisors. There's going to be a lot of questions for random drug testing because it really comes down to basically a probable cause or reasonable suspicion testing. Now, can we use a test? Yes, if it's in combination with these observable signs, but it's a very, very unique one. And please look at this if you had it. It really changes the process for this. Rhode Island, 2022. This is a unique one. For safety sensitive employees, for the first time that I'm aware of, they put a time limit. You can prohibit use within a 24-hour period starting work. Now, that can be in policies. Do we have a mechanism in standard drug testing to tell? We do not. You know, the idea of even oral fluid, which is often 24 to 36 hours. So right now, most of the experts are telling me that, you know, 24 hours is great and you can put that in your policy and people will be on the honor system to do that. Do we have a definitive to assess? Yep, they consumed within 24 hours. Not right now. Not right now. So, but it's in effect, and you know, no matter what it is, I think people are glad to see a time limit. I will tell you scientifically, people are not sure what this means, but I think it does help. So this is the actual law of it. It's, again, they don't want to take action for illegal use outside. Now, they do have a safety sensitive list, but it's not exclusive. Again, every time I come up to safety sensitive, remember, the burden's on the employer to determine it. So if they fit into this, great, you got an automatic. If they don't, you're going to have to justify it. And I would recommend justifying it in advance. You know, it's not very nice to say after you get a positive, yeah, Joey's testing. You know what, now that I think about it, he is safety sensitive. Do it in advance. You're going to be a lot better off. All right, this is the final. Don't have to let him use on the job. All right, so those are the positive ones. We have 11 states that have said no employment protections exist. Nevada, that is for current employees, and that is a case we're going to talk about. Remember, Nevada pre-employment, they have protections. Current employees, they don't. And these are the states, but again, we're watching this. Nevada, and I will confess to you, I was a little surprised at this decision. Nevada has a very, very robust off-duty use law. But basically what Nevada Supreme Court said, federally illegal, you don't have to accommodate current employees. I'll be curious whether the legislature takes this up. When they passed the law for pre-employment, that question was asked of the committee and they said, oh, well, current employees are already protected. Well, Supreme Court didn't agree with them. So this is an interesting one, and it just shows never predetermined what the results are going to be. Because I'm not a betting person, but if I would have had to bet on this one, I would have bet the opposite, given the history in Nevada. But there you go. This is the case for those who want it. My contact information at the end. If anyone just really can't sleep at night and wants the case, just let me know and I can provide it. So unclear, all of these 6 states. Doesn't say it, doesn't say yes. You can read the tea leaves and say maybe yes, maybe no, but these ones, it's either limited or unclear. Maryland, for example, says it doesn't address employment. It says prohibits smoking cannabis or smoking tobacco. Doesn't address the employment. So we're going to have to wait for either guidance to come out or a case. I know nobody wants it to be their company to be the case, but there you go. Missouri, kind of the same thing. It says that they don't prohibit an employer from disciplining for working under the influence or using on the job, but it is 100% silent as to what happens for off-duty use. Now, Some legal scholars would say, oh, well, that means it's protected. And some people would say it isn't. So that's what the sort of uncertainty comes to. Let's talk about this. And I'm just going to tell you the difficulties with the changing law. Number one, and I think we've talked about all of these, but let's just sort of say them out loud. And you and your legal department really need to think about the risks, because what we're really, this is a trade-off between historical cannabis use being viewed as impacting safety and the risk of litigation and maintaining a workforce. Every company is going to have a different risk profile depending what they do. First off, there's no objective standard for impairment, and it is subject to challenge. What does it look like? How do you, and of course, how does cannabis impairment compare with other types of impairment? Not a great one, and many states have a different standard. I can tell you the DOT standard that we use for reasonable suspicion is a good start, but it's by no means applicable in all the cases. In many states, there's no exception for safety sensitive employees, which is, look at California, you know, which is going to go into effect, or New York, which is in current effect. I always have people ask me, but I have crane operators. No, they're not DOT employees, but I have crane operators in New York. Surely I can do testing for cannabis and take action. No, that's not legal. Sorry, you can't take action based on a positive drug test alone. You need objective signs and symptoms of impairment. And there's no standard consensus on safety sensitivity. Please read these states. I've given you many of them, but they're varied. You look at the new standards, the wire, the 24-hour period. Sometimes I think this is literally the American experiment in cannabis legalization. We're the only country in the world that's ever done this. We can look back in 15 years and talk about our experiment, but I can tell you, while we're in the midst of it, there's a lot of confusion. I'm trying to bring as much clarity as I can, but the fact is where you're at, the type of employees you have, make a difference. And all you can do is do the very best you can and talk about it. Okay, CBD and hemp. I'm going to do just a couple slides just to bring us up to date, because it's really minimizing. We all know in 2018, arguably everything besides Delta-9 THC became legal. Federally, of course, HHS and DOT don't accept hemp as a reasonable medical explanation. Here's where most of the controversy is today, Delta-8 and Delta-9. Delta-8, illegal under the Farm Bill. It is still a Schedule 1. Delta-8 is derived from hemp. I think there was, it doesn't mention Delta-8. Remember, it's Delta-9 THC or hemp, and that's all there is. So it doesn't, you know, Delta-8 is being synthesized from CBD found in hemp, most generally. We don't know that for sure. When you have a positive drug test that has Delta-8 in it, you don't know where it actually came from, but that's what we understand in the industry that's happening. And one of the big questions is Delta-8 legal? And I can tell you the DEA and some others were giving some guidance that was mixed, to be kind. Well, let me tell you, in 2022, at least one federal court has ruled it legal. Delta-8 is legal. Now, you have to kind of understand this. This is the Ninth Circuit. And before anyone goes, well, that circuit does blank, it is generally regarded as this is the law of the land. Once a federal court, as we're aware in many, many circumstances, rules, until it's challenged, changed by it, or the Supreme Court overrules it, this is the law. And this is just reading the Farm Bill. So buyer beware, employer beware. As of right now, it is likely that it is legal, and a court would uphold it as legal in most jurisdictions. However, is Delta-8 impairing? You betcha. That is scientifically undisputed. We also have, and this is better for scientists, I won't go too much, there's often a mixture. So if they have Delta-9, that's the illegal part, but you have to understand. And of course, right now, while there is some offerings by labs on Delta-8, most aren't testing for it. But that is the standard, and that changed in 2022. Some states have either banned or restricted Delta 8 products. This is some of them, probably not all inclusive. This is a moving target. What it means is a little unclear. So with regard to this, for the hemp THC, one is the controversies around CBD are dying down. Not to say that you still don't have claims of, I only ingested CBD, and those all have to do with purity of product. But we don't know. Cannabis laws are continuing to change. I predict in 5 or 6 months, we'll have a different talk once we get the new state legislatures. Many are in session right now. And we just don't know. Usually most states end by May or June, and we'll see what shakes out. There is a complete lack of clarity on impairment. So the biggest thing I can say is consult your legal advisor. Lawsuits are expensive. And also you want to be able to do the right thing. You need to balance it, but consult your legal advisor. So here is my information. You're welcome to make comments, questions, anything. Please also put it in the Q&A. But with that, I think with a deep breath, that's the current update on cannabis. Thank you, Thomas, so much for having me.
Faye, we only have a minute or two for questions here, so I'm going to dive into this. Everyone else will answer your questions after Day with DISA. Thank you for participating and submitting them. Faye, we spent a lot of time on DC. Is that because you believe the provisions are going to spread to other states?
I don't know that, but I can tell you historically, once one jurisdiction comes up with innovative ideas for how to further expand cannabis rights, I'm going to call it, we often see them pop up in whole or in part in other jurisdictions. So this is very innovative. So of course I wanted to highlight it as a possible preview of coming events.
Gotcha. Next question would be, do you recommend removing marijuana from my panel if I have safety sensitive employees?
Absolutely not. Look it. Safety is job one. Safety of our employees, safety of the public, safety of everything. So if you have people where it's really critical and the law in that jurisdiction allows you to test and in whole or part take action, I absolutely recommend it, because I understand that removing it may be an easy answer, but it's not necessarily a safe answer. So emphatically, I don't, not for safety sensitive.
Awesome. Thank you so much, Faye. Appreciate you kicking Day with DISA off with a bang. And again, we'll hopefully see everyone in our next session.